Dylan Hall Senior versus Emily Hall. Defendant is not present.
Okay. Mr. Hall, good morning. This is the time and place set for the trial in this particular matter. The court will note that we had mentioned to you that we're going to wait for the defendant to again appear. We're going to give her 10 minutes. And then you mentioned that she has started a new job and was not able to get off from work. Is that accurate?
That is accurate, sir.
Okay.
We've been talking and trying to work some things out, being civil. We decided what was best for our kids because what's decided best for our kids is to stay friends. And let them know that mommy and daddy aren't fighting.
Okay. So with that, does that mean, have you come to an agreement as to what you were going to do or not?
Yes. So we discussed to actually go to counseling.
The two of you go to counseling, and what type of counseling is that? Is it there's a lot of counseling. There's marriage counseling, there's co-parenting counseling, there's
That is I think what she said was marriage counseling. She told me she left without putting her full foot forward. So we're going to try that route, and if that doesn't work, we'll probably come back and do a little quickie divorce.
Okay. Well, what's going to happen if you're the plaintiff, you have a right to dismiss the case if you wish to do so. The court's not going to leave it open though, because it's already 146 days old. So,
no, see, that's, the kids are with me. They've been with me for a minute now.
okay.
They've got a routine. Junior's starting school here in Eaton County, September 5th.
Okay. I do note that there was a temporary order back on April 13, 2023. Then we did a subsequent order on May 9th, 2023. I'll let you know if we dismiss the case, those orders get dismissed. You understand?
Well, so you ruled on me getting custody of my son. That's getting dismissed?
Yes, if you dismiss the case, that dismisses those orders. Those orders do not exist then.
Oh, I didn't know that.
Yeah. Yeah, you can't dismiss a case and then say, oh, we want to rely upon the orders of a dismissed case, because those orders don't exist then. If we complete the case and then there's a final order, then in fact that order proceeds even though the case gets dismissed. Well, the case gets finalized, let's say, not dismissed. If you dismiss the case, then all of those orders that have been entered to this point would get dismissed as well.
Oh, no, I don't want to dismiss the orders. That's something me and her discussed. We wanted to go to marriage counseling and see if we can work this out.
Okay, but I'm just telling you, that's fine, but I can't keep the case open while you're in counseling to see if it's going to work out, because the case is already 146 days old. I don't know, maybe it takes you 6 months, 9 months, a year to work things out. And the court, I just will not leave the case open that long.
So, can we, I don't get, we decided the kids would stay with me. So she wants an order in place stating that the kids will stay with me, because right now her living situation is not right.
Okay.
The other day, Chris threw her phone, broke her phone. They got in an argument. Chris pushed her. I'm not having my kids there.
Okay. Well, that's fine. We can enter, if you don't wish to proceed with I'm just trying to think the way to do this. If you don't wish to proceed with the divorce, but you want to work some of that out, we could do a final order for custody, parenting time support, and then dismiss the balance of the case if you wish to do that.
Yeah, let's get the final, let's get the custody orders like you said. And we'll go the route you just said, sir.
Okay.
But Delilah does have daycare scheduled for that tap zone there on M66.
Okay, and you're telling me that why? Why is that?
Oh, I'm just that's daycare. So she's got a place to go so I can work. So
Okay.
it's a Head Start program so she can get ready for school
Okay.
in the next couple of years.
Okay. Well, let's do so. I am going to need to take some testimony from you to establish a basis for custody. Sir, as I'd stated to you previously, that you had a temporary order of 4/13/23, and then another order on May 9, 2023, which granted you physical custody. The second order, you agreed to a joint legal custody of Dylan, but not with regard to Delilah. Let me ask, prior to those orders being entered, where were the children primarily at?
They've been with me this whole time, sir.
And that's from the date of separation?
That is from the date of separation, yes.
Okay. You have the date of separation as January 10, 2023, and the defendant in her answer said it was March 1, 2023. Could you clarify the date of separation?
The day she said March of 2023?
Yeah, she said March 1 of 2023, and you had January 10.
Well, she was in and out of the house for weeks on end in January. I had no idea where she was. So that's why I put the separation at that time.
Okay.
Then I asked her what kingdom she wanted to be in. Like, if you wanted the kingdom I'm going to build, or you want the kingdom he's going to build. She chose him.
Okay. So when did she, sometime in January is when she started to not be home, correct?
Yes, sir.
And from that date to the current date, have you been the one that the children have principally been in your care?
Yes, sir.
How, let's say since January to the current date, how often has she, let's say how many times has she seen the kids?
You mean kids?
No, the kids, Dylan, Delilah.
Last weekend was her first weekend in over a month.
Okay, and let's say since January, how many overnights has she had the children?
Since January?
Yes, approximately.
None. And she used to come in the morning, grab the kids so I can go to work around 2:30. But when I got home at 11:30, the kids were sound asleep in the bed and she was nowhere to be found.
Okay, and that's happened since January?
That's
Or that happened in January?
that happened in January, sir.
Okay.
And I tried to call her on the subject and she wouldn't pick up my phone.
And let's say since the time that happened, and let's say since the time that she was out of the house and wasn't coming in the house, how often has she seen, since January, And you said there were times that she'd come in when you were working and then when you get home, she was gone. Is that accurate?
That is accurate.
Okay.
Let's
say since January, starting February 1, from February 1 to the current date, how many times has she had the children with her?
About 8 hours a day, because she was watching the kids while I was working 60 hours a week.
Okay. And was that every day?
No, that wasn't every day. Around January 1st, I was having to take multiple days off work because she refused to show up to babysit the kids.
Okay.
So I could go to work.
Okay. When did she leave the house and she was gone from the house completely?
The day I dismissed her from the house was the day I asked her what kingdom she wanted to be in.
Okay. I'm not asking that. I'm asking what day was that? Are we talking January 25th, February 4th? When?
That would have been like end of February.
Okay. And since the end of February to the current date, how often has she seen the children?
There was a good like 3 weeks where she was seeing Junior every other weekend. Then she told me she didn't have money and she couldn't afford, and Chris wouldn't let her come see the kids. So like I said, there was a month chunk in there that she didn't Zoom call. She didn't get Junior on the weekends. On the spot we decided to meet in Bellevue at the park, she was been no shows.
Okay. Well, what I'm trying to discern, sir, is the time that she's been with the kids and the time that she hasn't, because that's important, obviously, in the case. So you said from the end of February through the current time, you said there are 3 weeks, about 3 weeks where she had alternating weekends, but then she didn't see them. So that's what I'm trying to discern, is when was the date that she really stopped having contact with the children?
The day you entered the temporary order on Delilah is the day she.
So April 13th was the date we entered the order.
You entered the order there, then you granted her every other weekend, May 9th, and she went a while getting him every other weekend. Then she went for a month, no contact at all.
Okay.
But then, like we started talking every day. I've been letting her Zoom call the kids because she wanted to be back in their lives. She's been trying to get away from Chris.
Okay.
And
when was it that she began Zoom calling the kids?
Again, that would have been it's been about a week. Then I let her come to Junior's karate yesterday to see the kids also.
Okay. So for about a week, she's been Zoom calling the kids.
She's been Zoom calling the kids. She's been in constant communication with me. She's been, I just think a light bulb popped in her head and said, hey,
Okay. Well, tell me a little bit about do you have a relationship with the children such that you exhibit love, affection, and have emotional ties? I mean, are you bonded to the kids?
100%. Am I bonded or is she?
Are you?
100% am I bonded to.
And what do you point to show that you have a bond with the children?
What did I point to?
Yeah.
I'm not following.
Okay. Well, how is it exhibited? How do you know that? You say I'm bonded to the kids. How do you know that?
Wow. Well, I am their father. So, like me and Junior, when we bond, we go out and shoot baskets, like hoops. We talk, we communicate that way. That's how I was raised. So, he opens up when we do that, and we bond in that way. And me and Delilah, we go for bike rides. We sit there and color on the floor. like me and Junior, we go to karate, and that's teaching them about discipline and stuff. And we bond in that way. We go out after karate, we get ice cream. We communicate that way. But ever since we've been starting to go to church, my kids have been better off.
Okay, what church do you go to, sir?
I go to the Community Baptist and off of St. Mount Hope Highway here in Lansing.
Okay. And how do you go? Are you a regular church goer?
Yeah, I go every Wednesday and every Sunday.
Okay. And the children go with you?
Yes, every Wednesday and Sunday.
Okay. Does Miss Hall, is she attend church?
I asked her to attend multiple times, but she grew up in a Catholic high school, meaning in a Christian high school. And she had that stuff pounded down her throat. So she's a Ray right now when it comes.
Okay. My question was, does she go to church or not?
Oh, then no.
Okay.
No, sorry.
Do you notice as far as the children, when we talked about the bonding, are there signs of affection that go between you and the kids to you?
Yeah.
And how's that exhibited?
Well, when I come in the door, my kids run and give me hugs. They hang to me tightly. Like whenever there's a problem or something scary happened, they come to me and they know I'm their protector.
And you say that your son will be going to school, or do you engage in any, let's say, educational activities with the kids?
Yes, I do. I got charts downstairs, like number charts downstairs, letters. My daughter she has these little animal blocks. She puts them in the puzzle, and before I let her put them in the puzzle, she's got to tell me the animal name.
Okay.
Junior can count to 20. I'm teaching both my kids how to read right now. Junior can read and do a lot of sight words. He's a very smart kid. And he helps me fix the cars and stuff. I teach him about life when we're doing that.
Tell me, since she left in approximately, let's say, February, has she contributed anything for the financial care of the children in the way of food, clothing, medical care, any other type of care? Has she provided you with any money?
She has not provided me with any money. No.
Okay. If she didn't provide you with money, has she provided you with any direct care as far as buying any food, clothing, or anything of that nature?
When Junior's over there, she goes out and buys him clothes. Yes.
And how long have you resided in the address that you're at?
Since the middle of May. Well, that's total, or just since I moved back from Battle Creek?
You can tell me since May is when you were back at your current address, and where were you prior to that time?
20.
And how long had you resided at that address with the children?
We were there for a year.
Okay. At the current address that you're at, I take it because you're going to church in Lansing. It's in Lansing?
No, I live in Eaton County, sir.
Oh, Eaton? Okay.
I live in Charlotte.
Okay. And do you plan on staying at that address?
Do I plan on staying in Eaton County? Yes.
Okay. So you have no plans to move at this point?
No, because my kids' education is more important than me.
Okay. Do you feel that, well, tell me, how do you feel? Do you feel that the defendant is in a stable situation?
I do not think she's in a stable situation. No.
And why do you say that?
Gotta go. I'm in court. Sorry about that. My oldest daughter just come in.
Okay.
So you, what was your question? I'm sorry.
The question was, why do you feel that the defendant's household is not a stable situation?
Well, she's getting harmed. She's getting beat. She's getting, my kids were being assaulted. And she told me when I saw her yesterday that she had to get out of there because Chris is hurting her. Her phone that I bought her a year ago, Chris threw it and shattered it. So that's why I think it's a not stable situation for her. She needs somewhere where she can live properly.
Okay.
I'm not.
Are you are you residing with any significant other or anything of that nature?
Right now,
What?
right now I'm at my parents' house.
Okay. So do you have any significant other at this particular point, or no one that you're seeing seriously?
No.
And other than you said the individual she's with, do you know whether she has anyone that she's I guess you'd say in a more of a permanent relationship?
No, he's the only one.
Okay. Is there are there any issues in your life that you believe that impact your moral fitness to raise the kids?
No, I don't.
How about the defendant? Is there any drinking, drugs, verbal abuse, anything of that nature that's occurring in her household?
Are you asking me if she's capable of raising our children, or is the
No, I'm asking you if there's anything going on in her household that impacts her moral fitness to raise the children.
Yes, there's concerns in that household, but she's more than capable of raising our children. Yes.
Okay.
If that's the question you're looking for.
Do you have any mental or physical health issues that would impact your raising of the children?
No, I do not.
Does she?
Yes.
And what is that?
She's been dealing with depression. I mean, I can't really tell you what happened when she was a child because all them records are sealed, but I know that she suffers from mental illness. Yes.
Okay. During the time that this matter has been pending, have you attempted to work with her to make sure that she stays involved in the children's life?
Constantly, every day, I text her. Hey, you want to talk to kids? Hey, you want to meet up so we can go to the park so you can see the kids?
I do note that back in June, we did have, there was a petition to hold her in contempt, that she was found to be in contempt at that point for denial of parenting time. Is that accurate?
That is accurate. She kind of stole Delilah when she wasn't allowed to have Delilah any overnights. So.
Okay. And then didn't return her?
She did not return her. Delilah's been in my care since that date for about 3 weeks now.
Okay.
Like I said, the light bulb just popped on and say, hey, you know, I'm doing bad. I got to straighten up here.
Okay. And you stated that there are instances of domestic violence in her home?
Yes.
Okay. How about when the two of you were together, was there any domestic violence occurring between the two of you?
Yes, sir. I went to intervention court,
Okay.
but that happened when I was on chemo. So I was sick at the time. But I did need it, sir. It was a good education.
Okay. You mentioned that you had another daughter in your home, and how old is she?
She just turned 9. Like just turned 9.
And does she reside with you full time or part time?
Yes, I've got full custody of her also.
Okay. And what is the relationship between this daughter and Dylan and Emily? I'm sorry, Dylan and Delilah, I'm sorry.
Well, that's big sister. I can tell you that. There's not. She will protect them. She plays with them. They absolutely love each other.
Okay. Anything else, sir, that you would like me to be aware of in deciding this matter?
No.
Okay. Okay. Anything else you'd like to tell me?
No.
Okay, thank you. Well, the reason you'll see is I ask you these questions is I'm required to under the Child Custody Act, which is MCL 722.21 at SEC in this matter. And the first job that the court has in deciding custody is to determine whether an established custodial environment exists. An established custodial environment exists if over an appreciable time the children naturally look to the custodian in that environment for guidance, discipline, necessities of life, and parental comfort. The reason that's important is the court cannot change the established custodial environment unless provided with clear and convincing evidence that it would be in the best interest of the minor children to do so. In this matter, when the court had asked, the court will note that this matter was filed back in sometime in January of 2023. That, see the exact date. I'm sorry, the summons and complaint was in March of 2023. That as a result, on April 13, 2023, the court did enter a temporary order which placed the children in the care of the plaintiff, and the defendant was to have supervised parenting time. Subsequent to that, that was changed and modified on May 9, 2023, but still provided the plaintiff with primary physical care, but provided the parties with joint legal care of Dylan Jr. It does appear, based upon the testimony of the plaintiff, that, again, he is the one that's been providing the children with guidance, discipline, and the necessities of life and parental comfort. He talked about how the children will come to him when they need things, they'll talk to him, et cetera. So the court will find that, again, that is what's exhibited here in this particular case. The court then has to go through the 12 factors of the Child Custody Act to make a determination on custody. The first factor is the love, affection, other emotional ties existing between the parties involved and the children. The plaintiff testified about, again, the love, affection that he exhibits, talks about the children will, when he comes in the room, will run to him, they'll hug him and they hang on him. If they're scared, they come to him. And it does appear that, again, they are bonded to him, as he stated. I've not heard any testimony about the children being bonded to the defendant. As a result, the court will find that this factor does favor the plaintiff father. The next factor is the capacity and disposition of the parties involved to give the children love, affection, guidance, and continuation in the education of raising the children in a particular religion or creed. He testified he does go to the Community Baptist Church in Lansing, that they go regularly on Wednesday and Sunday with the children. She testimony as well that the defendant does not have any church affiliation. She doesn't go to church. She's also testified that he has the Dylan Jr. He has him enrolled in school up in Eaton, up in Charlotte. and that he's starting. He also testified about how he works with them on their numbers, colors, that Dylan can count to 20, that again, it appears that, again, he is prevails on this particular factor, and this factor favors him in contrast to the defendant, who we had no testimony on. The next factor is the capacity and disposition of the parties involved to provide children with food, clothing, medical care, and other remedial care permitted under the laws of the state in place of medical care and other material needs. In this case, the testimony has been that since their separation in approximately February of 2023 through the current date being August 8, 2023, that the plaintiff is not, the defendant has not contributed to the financial support of the minor children in this particular case. He did testify that when Dylan is with her, that she will buy him clothing, but that is the extent of it. The court will find that this factor does favor the plaintiff father. Next factor is the length of time the children have lived in a stable, satisfactory environment, the desirability of maintaining continuity. He's testified that he had previously been in address in Battle Creek for about a year. He's now living with his parents, and that has happened since mid-May, that he has no plans to change in that situation. He did state that he has been informed by the defendant that she's residing apparently with a boyfriend, but she has testified that it's a kind of a tumultuous relationship, that she has been assaulted, the kids have been assaulted, and as a result that she has to get out of there. So clearly that is not a stable, satisfactory environment. The court will find this factor does favor plaintiff father. Next factor is the permanency of the family unit, the existing or proposed custodial home or homes. He stated that he does not reside with any significant other, does not have a significant other. The court again notes that the defendant does, but it's again a tumultuous relationship. So the court will find that this factor does favor the plaintiff father. Next factor is the moral fitness of the parties. There's been no testimony about moral fitness. The court will not weigh that in fact in favor of either of the parties. Next factor is the mental and physical health of the parties involved. The court will note that in this particular matter, he states that he has no mental or physical health issues in this particular case. However, the defendant has suffered from depression and mental illness since being a child. The court will find that this factor does favor the plaintiff father. Next factor is the home, school, and community record. The children are not of an age to have a school or community record, and the home record is minimal, but it does appear that, again, the plaintiff is providing that direction and assistance to the kids as it relates to their education, and is, again, providing them with a good home environment that we've previously testified to. So this factor would favor the plaintiff father. Next factor is the reasonable preference of the children. If the court determines the children to be of sufficient age to express preference, I did have opportunity to speak to Dylan Jr., and again, I'm taking that into consideration in this matter. Next factor is the willingness and ability of each of the parties to facilitate a close and continued parent-child relationship between the child and the other parent. And in this matter, the court heard the testimony of the plaintiff, in which the defendant had denied him. She had taken Delilah at a time when she could not take her because she was under an order for supervised parenting time, that she took her for a number of weeks. And in fact, the court did find the defendant to be in contempt of court back on June 15, 2023, as a result of that action. And the plaintiff was awarded 4 weeks of make-up parenting time. As a result, the court will find that this factor does favor the plaintiff father. Next factor is domestic violence, regardless of whether the violence was directed against or witnessed by the children. The plaintiff testified about that there were some acts of domestic violence in the home when the parties were together, that he had to go to some sort of an intervention court, as he stated. The court also notes he's testified about domestic violence occurring in the defendant's home. So the court is not going to weigh this factor in favor of either of the parties. Next factor is any other factor considered by the court to be relevant. The plaintiff testified that he does have a 9-year-old daughter who resides with him full time. He has full custody of her, that she acts as a big sister to both Dylan Jr. and to Delilah, that they love each other, have a good relationship, the court is taking that into consideration and finds that that factor does favor the plaintiff father in keeping the children all together. When the court does this, because the established custodial environment is with the plaintiff, he need only show by a preponderance of evidence that it is in the best interest of the children that the children remain in his custody. However, the court will find that the evidence has shown by clear and convincing evidence that it is in the best interest of the minor children that they continue to remain in his care. The court will therefore grant the plaintiff full and sole custody in this matter. Court then has to look at parenting time pursuant to MCL 722.27A. And again, the considerations the court has to look at. Those factors are there any special circumstances or needs of the children? There's been no testimony about that. Next factor is whether the children are less than one. There's no testimony about that. The children are not less than 1 year of age. Next next is the likelihood of abuse or neglect of a child during parenting time. There's been testimony that, again, that from the plaintiff that the defendant herself had stated the children had been abused apparently by the live-in boyfriend. The court would note that the court did initially in this matter, based upon various allegations and at the hearing, did in fact determine that, again, the only parenting time should be supervised parenting time, and did put an order in place to that effect. Next factor is likelihood of abuse of a parent during the exercise of parenting time, not applicable other than as previously stated. Next factor is the inconvenience or burdensome impact of travel on the child. Parties reside reasonably close together, so the court will find that not to be a burdensome impact. Next factor is whether a parent is reasonably expected to exercise ordered parenting time. In this matter, although the defendant did not have any stated parenting time, that again, she has been sporadic at best in exercising the parenting time that she did for a period of time, as the plaintiff stated after the May 9th, 2023 order, that she did exercise alternating weekends with Dylan, but then she's had no contact since just a couple of those weekends, that he has been the one that's assisted and contacted her almost a daily basis of whether she wants to have contact with the children or see the children. I should have mentioned that under the prior factor, and I didn't. But the court will note in that matter that he has attempted to facilitate that. Next factor is whether a parent has frequently failed to exercise parenting time. Obviously, she has failed to exercise parenting time, and that she's not taken the children as she's been provided the opportunity to do so. So the court will consider that. Next factor is threatened or actual detention of a child. Again, there was this incident that occurred in which she kept Delilah, and she was held in contempt back on June 15th, 2023 as a result of that. So the court is taking that into consideration. And any other considerations, the other considerations would be considerations of, again, the best interest of the child test under the Child Custody Act. The court is taking those into consideration this matter. As a result, what the court is going to do is simply order that the defendant would be entitled to a parenting time at all times and places to which the parties may mutually agree. So that will be up to the two parties to agree as to the parenting time, but I'm not going to put in place at this time any scheduled or regular parenting time for a number of reasons due to the upheaval in the defendant's home. Also, the fact that she has failed to show at prior hearings. She failed to show to the hearings in June of 2023. She's failed to show up today. The court notes it is now 9:22. The matter was set for 8:30. She is not shown and has not contacted the court at all about hearing or anything else. And as a result, I thought it'll be incumbent upon the defendant, if she wishes to pursue parenting time in the future, that she will have to file and provide the court with a appropriate basis for the court to enter a custody or a parenting time order at that time. court likewise has to address the issue of support. I've not heard any testimony from the parties. I'm going to leave that up to you, Mr. Hall, to put in place a support order. In this case, what happens is when you put together your judgment, and it would be a final judgment for custody, parenting time, and support, you'll have to do a support calculation, which you'll have to take your income, put that in the calculation. You'll have, because you have your daughter with you, your older daughter, you'll have to put her in as an other child. You want to make sure that, and then you can put in the defendant. I don't know if you're aware of what her income is. If not, the court would allow you to impute income to her of $15 per hour. That is pretty standard in this area at this particular time. And then you will come up with a support calculation, and then you'll do a uniform child support order as well.
Sir, can I put this on the record? I do make 10 times the amount of money she does.
Okay, that's fine.
Right now, I'm still paying her child support.
Okay, then obviously that's going to be canceled. So you'll cancel that immediately. You'll put in a new support order, which will require that she pay you support based upon her income. Even though you're making substantially more, she's still going to have to contribute something. Okay, so if you utilize a service such as MichiganLegalHelp.org, when you get to the final judgment, yours is going to be a little bit different because you're not proceeding with a judgment of divorce because you didn't want to proceed with that. Is that accurate, sir?
Yes.
Okay. So you're going to simply do a final order for custody, parenting time, and support.
Okay.
And so you'll have to do that final order. You do a uniform child support order, and you will do a judgment information form. And all that is contact information on you, contact information on her, and then you will turn all three of those items into the front of the court to get their approval. And when they approve it, then the court will be able to enter it at that time.
All right, sir. I'm sorry, but can you go over this again so I can write it down? It's just a lot of.
Well, a couple things. What happens? This is being recorded on YouTube. You can go to YouTube and review this. Okay.
Okay.
So just go to YouTube, put my name in, it'll come up on today's date, and you can go over it all at that time.
All right, that works great. Thank you.
But make sure and get that in. It takes time, and oftentimes people will, when they're preparing those orders, and being that you're a lay individual, you won't know. Oftentimes they don't include everything that they're supposed to include, and the front of the court will sometimes object.
Yes.
If they object, they give you a form and they check a box off as to what their objections are, and then you've got to correct that. There's going to be provisions that appear in the orders from Michigan Legal Help that are standard provisions that are required to be in the order. Don't delete those, okay? Sometimes they talk about parenting time not occurring in countries that don't subscribe to the Hague Convention. First, a lot of times people, what is this? They have no idea. Make sure you just leave that in there because that will be an objection if you don't include that. Okay, and there's a lot of those types of objections. So the important thing is you have to know is that you're being granted sole legal and sole physical custody, that she gets parenting time at all times and places which the parties may mutually agree, and that's it. And then the provision for the support will be in a separate uniform child support order. Any other questions that you have, sir?
No, just one quick question. So you granted me custody of both kids, correct?
Correct.
Okay. That's all I need, sir. Thank you for your time.
Okay, then what happens is we will just do it. MichiganLegalHelp.org takes you kind of through the process. It's a pretty easy process, but make sure you do it and then go back to the YouTube if you have any questions.
All right, thank you.
Okay, thank you. The court will conclude this matter at 9:28 a.m. Court will note that again that the defendant has not appeared at all, so even at this time, so we will conclude the matter. Sir, best of luck to you. I hope everything works out for you.